In this video, I'm just going to give you a short indication or explanation about the actual divorce proceedings. They are similar in the High Court and the Regional Court, depending on which court you go to. But the Regional Court is far more aligned to parties who are self-represented, who don't have access to funds to pay for attorneys. So if you want to do it yourself, you can do that by going to the regional courts, and the registrars at the regional courts are specifically trained to assist you with completing the necessary documentation and getting everything done. But just to give you an explanation of what the procedure is, the first step is that if you are going to institute divorce proceedings, you are known as the plaintiff and your spouse will be the defendant. You have to have a summons issued out of the court, whether it's the High Court or the Regional Court, and attached to the summons is a document called a particulars of claim, and that sets out what it is that you are looking for or seeking in the divorce. So this could cover things like a division of a joint estate or a calculation of the accrual. It could cover maintenance for yourself, so spousal maintenance, care and contact arrangements for minor children, and maintenance for minor or dependent children. So those are the sort of things that are covered in a divorce summons and particulars of claim. The court that has jurisdiction is the court in the area in which you reside or consider to be your permanent place of residence for at least a year. So if you've been living in another country and you've only been living in, let's say, Durban for 5 months, that court won't yet have jurisdiction. You have to have been living there for a minimum of a year, unless it's your domicile. So make sure that you choose the correct court. You can't, for example, be living in Cape Town and issue a summons out to Johannesburg. It has to be where you reside and regard as your permanent place of residence. So once you've had the summons issued, that then has to be taken to the sheriff, who is the sheriff in the area where your spouse or the defendant resides, and that has to then be served on your spouse. And because it is a divorce, it has to be served personally. It cannot be served on anybody else. It can't be served on a staff member at his place of work. It can't be served on a gardener at your home. It can't be attached to a door or slipped under a door or put in a postbox like summonses in other actions can be. It has to be given to them personally in their hand. So you have to make sure that you instruct the correct sheriff to go and effect service at the correct address. And the address must be correct. There are other procedures that can take place if you don't know the address of your spouse, but I'm not going to deal with those in this video. That will require you to obtain some legal advice and legal assistance. Then, following the service of the summons on the defendant has 10 days, and these are court days, to file what we call a notice to defend, which is basically a notice saying, I intend to defend, unless he or she does not want to defend and is happy to go along with the order that you are seeking in the summons, in which case they don't need to file a notice to defend, and the divorce can be set down on the unopposed roll and can be taken fairly easily. If they do want to defend, they have 10 days, like I said, to file a notice to defend, and then they have 15 days from that date to file their plea. And that has to say whether they deny or admit any of the allegations that you have made in your particulars of claim. And they can also then file what's called a claim in reconvention, sometimes referred to as a counterclaim. And this is where they set out what they want from the divorce, which can include all the same things that you have asked for in your summons and particulars of claim. You then have an opportunity to file what's called a plea to the defendant's claim in reconvention. And once all of those documents have been filed, then it is considered that the pleadings are closed and there are further steps that need to be taken after that. Now, in the Gauteng division, this includes Johannesburg and Pretoria in the High Court. In terms of the latest directive, parties to all civil proceedings have to attend mediation prior to applying for a trial date or a trial date being allocated. Now, this doesn't mean that you have to go to mediation for the next 5 years trying to resolve things. It doesn't mean that at all. You need to go to at least one session and attempt mediation at the very least. And unless the matter is absolutely not capable of mediation, and then you have to set out in a notice, it's called a Rule 41A notice, very clear reasons why it cannot be mediated. Examples may be things like there has been severe domestic violence, in which case a court is not going to force parties to mediate. There may be serious mental health problems, which may mean that one of the parties is unable to mediate. So there are things which may render mediation the incorrect procedure, but that has to be set out in a notice to explain why. So the other divisions have not given a directive as to mediation yet, but there is a bill that's on its way, which is going to take a few more years, but that is going to come in. And it is likely that the other courts are going to follow the same procedures that are being followed in Gauteng with regards to mediation. So again, mediation is something that you may well have to consider. And if you don't want to consider, like I say, you're going to have to give very cogent reasons as to why you are not prepared to go to mediation. So again, the courts have different ways in which they manage their own matters, but procedurally, after the pleadings are closed, then you have to do something called discovery, which is where you have to basically tell the other side what documents you are going to use at the trial. And these could be financial documents, bank statements, deeds, trust documents, whatever documents are relevant to the issues that are in dispute in your divorce, whether those are patrimonial, maintenance, or child-related issues. You will have to discover those documents, and you set out in an affidavit what items you are going to use at the trial. Then there are other rules that relate to bringing in other evidence, such as videos or expert evidence, photographs, and those sort of things. And you have to follow those rules to make sure that that evidence is correctly placed before the court. Once all of that has been done, you also need to have what's called a pre-trial conference. In the High Court, there's a very specific format that has to be followed. There are very specific documents that have to be completed. There's got to be a minute of the meeting. There's a trial readiness checklist that has to be compiled. And again, each division has slightly different formulations of the same rule, but they're slightly different. So you have to make sure that you understand what the procedure is in your specific court that you are going to. If you're at the regional court, the registrar will be able to assist you if you don't have a legal representative. Otherwise, this is something that your legal representative will know. I'll give you an example. In the Durban and Pietermaritzburg High Courts, once the pleadings are closed and all the discovery is done, there are certain other things that you do, but you hold your Rule 37 conference, which is your pre-trial conference. You compile all the documents, you get all your trial bundles ready, and you then do a specific notice setting the matter down and asking the registrar to give you trial dates. And once you've complied with everything and you've jumped through all the hoops that you need to jump through, you then wait for approximately let's say 3 to 5 years to get a trial date. In the Western Cape division, it's a bit different. You don't do the Rule 37, which is the pre-trial conference. You do the discovery, you do all of those things, and then you fill in a certain form asking for a court to be allocated for you to have the trial. And you could, again, you're probably going to be waiting a number of years before you get allocated, and you only do the pre-trial conference just before the actual trial. So each court has different ways that they do things, but there's a lot of stuff that goes on in the background if you do have legal representatives that you may not even know is going on, or you may have to sign an affidavit or those sort of things along the way. But generally speaking, from the time you institute divorce proceedings until the time you actually go to trial is anything upwards of 4 years. And in most of the divisions, you're looking at least 5 to 6 years before you get to trial. So you need to bear that in mind. And again, it's another reason why I say, please, please, please try and get to mediation before you start the whole divorce proceedings thing, because you are literally going to give away 5 years of your life where you're going to have energy focused on that rather than on moving forward and getting on with your life. Now, if you are lucky enough to go to mediation, or to just between you and your spouse come to an agreement and settle, that is first prize, because then you can essentially be divorced within the space of 3 months. So you still need to have a summons, and that still needs to be issued, and that still needs to be served on the defendant. But in cases where you've settled, you attach a copy of the settlement agreement, and where there are children involved, you attach a copy of the parenting plan, and that then gets served on the defendant, and then the defendant doesn't defend the matter, and the matter can get set down, as I said earlier, on an unopposed roll. And with that, you are getting dates in 2 to 3 months' time. So that is why I say to you, it's far better idea to try and resolve the disputes very early on, because that way you can literally get divorced within a matter of months, rather than waiting for years and years and years. And during that time, your life is essentially on hold, because if you have to remember the patrimonial consequences of the divorce. In other words, the value of the estates is calculated on the day of the divorce, not the day that you issue the summons. So you might be working really hard to increase the value of your estate, and you are investing well, and you may have bought and sold property, and so the value of those has gone up. And if you're living in the Western Cape, the value of your property has skyrocketed by 50 or 60%, and suddenly your estate is worth much more 5 years later than what it was at the time when you started the divorce proceedings. But your spouse, on the other hand, has got a gambling problem and has squandered everything they have and is now basically living hand to mouth. And where you could have potentially at the start of the proceedings had the same value of your estates, you've now got this massive disparity, and you land up having to pay your spouse out a huge amount of money. So these are things that you have to consider right in the beginning. And that is why settling through either between the two of you or through mediation, it's a way better option than going to a trial. I hope this information will help guide you on what the procedure is and the best way to deal with a divorce matter. What happens if you don't agree and there is going to be a dispute? There's a few things that can happen. In a Rule 43 application where you've applied for maintenance for yourself, you can also use that to get an order relating to care and contact and also maintenance for children. Now, the maintenance for the children is determined by where they live and how often they see each parent. Because if they live in 50-50 and both the parents are earning the same amounts, then maintenance is going to be shared equally. Because maintenance for children is calculated based on the children's needs and then the parents' means. So let's not deal with that right now. Let's just deal with the care and contact. Now let's say you're in dispute and you want to bring Rule 43 so that you can have primary residence of the children pending the finalization of the divorce with your spouse to exercise contact every alternate weekend, for example. Very often, what the court will ask for prior to it giving an order is it will ask that the matter be referred to the Office of the Family Advocate. Now, the Office of the Family Advocate has specifically been set up to resolve issues relating to care and contact of children. They don't deal with maintenance. It's only care and contact of children, right? So if the court asks for that and the court wants you to go for that, a Rule 43 application could be adjourned to allow for that process to take place. Now, the Office of the Family Advocate has a limited resources, has limited capacity, and has so many matters being referred to it because there's now also the Children's Court and family courts that also refer matters to it. Domestic violence courts can refer matters to the Office of the Family Advocate. So the Office of the Family Advocate generally takes quite a substantial amount of time to, number one, consult with the parties, and number two, finalize a report. So don't expect that to happen in a hurry. This is another reason why I say if you can get the matter to mediation, it is way better for you, for your spouse, and especially for your children. The other important aspect to remember when it comes to care and contact of your children is that in terms of the Children's Act and the Constitution is that children have a right to have their views considered. Now, the terminology that's used is problematic. Some people like it, others disagree with it. The commonly used term is that the voice of the child, and I actually did my master's degree on the voice of the child, but in fact it's technically incorrect. What the legislation says is that children have a right to participate depending on their age and their stage of maturity. And what that means is that if you are going to make a decision about where the children are going to live and your children are 16 and 12 and they are, quite smart kids and they're doing well at school and they've got a good understanding, they have a right to hear what the decision is about what's going to happen with them and to have an input into that. They're entitled to participate. Now, the Office of the Family Advocate, when they call you and your spouse into first they try and mediate between you, but if they're going to investigate and do a complete inquiry, then they will speak to both of you and they will speak to your children, regardless of your children's ages, unless they're really small, like, below the age of 3. But if they're little, they will watch how the children interact with you to see how they interact with both parents, to see that there's no, a child doesn't go running off screaming when they see one of their parents absolutely terrified or anything like that. And when the children are older, they've got things that they do with the children through drawing and play, where they can get an idea of what the children's views are and give them an opportunity to participate in that process, because children are entitled to that. More experienced mediators could themselves bring the children in and meet with the children to get an indication of what the children's views are, could explain to the children that, what you as parents have think is in the best interests of the children, and then gets the children to give their views on what the parents have discussed. It all depends on the mediator you get if you decide to mediate. The court is unlikely to make a decision about that without the input of an expert. So if it's not the family advocate, then, and you and your spouse are still in dispute about where the children are to live, or how much contact they are to have with the other parents, or if you want to stop the other parent from having contact because the parent is an alcoholic or a drug addict or whatever the case may be, you're going to need to get an expert opinion. And this could be a psychologist or a social worker who specializes in that type of forensic work. But please bear in mind that all these types of interventions can become incredibly expensive. And especially forensic investigations into care and contact, because they do psychometric testing of you and your spouse, and they meet with the children, and they meet with collateral people, teachers and family and friends and all that type of thing. So these type of investigations can become incredibly expensive and can also be traumatic to you as a family and to your children. So you want to try and limit those things. So the outcome that you want to try and achieve is always based on what's in the best interest of all children. So if you've got special needs children, for example, a 50-50 type arrangement might be too disruptive for them. Or you've got a child who does a lot of sport, and one of you as a spouse does a lot of traveling and can't be there on a regular basis to take that child to sport, to make sure the child's got everything he or she needs to get to and from school, and therefore the child needs to stay with the other parent. These are the type of things you need to take into consideration when you're deciding on the care and contact arrangements that are in the best interests of your child. Of course, you also need to take into consideration whether or not there are any issues such as drug or alcohol abuse issues, right? These are very important, obviously, because they will affect how a parent is able to cope with parenting, and in particular with single parenting. So these are the things that you need to think about when it comes to care and contact. Maintenance for children is calculated much the same way that maintenance for a spouse is calculated, except that it is then, once the needs of the children are determined, a pro rata type calculation is done based on how much the parties are each earning to determine how much the one spouse must pay to the other spouse for the maintenance needs of the children. To avoid further arguments arising, it is always best to try and have the spouse that is not the primary caregiver pay the maintenance directly to service providers. So, for example, paying school fees, school uniforms, stationery, paying medical aid, paying for medical expenditure, etc., and reduce the amount of cash maintenance payable, because unfortunately this can can be abused, or allegations of abusing this can be made, where the parent who's paying says that the parent who's receiving the money is spending it on having their hair and makeup done, or buying the latest shoes and matching handbag, rather than spending it on the children themselves. Now, when you calculate the needs of a child, all the shared household expenses are taken into account. So, for example, rent or a bond installment is shared between the parents and the children. There are different schools of thought on this, but the generally considered most commonly used one is that it's 1 part per child living in the house and 2 parts per adult living in the house. So if there are 2 children and 1 adult, it is essentially divided in half. 1 part for each child, 2 parts for the adults, so 50-50. So if your rent is 10,000, 5,000 of that is allocated to the children and 5,000 to the parent. And that is with all the joint household expenses. So that would be groceries, electricity, rates and levies. If there's a motor vehicle that is under finance, it's the motor vehicle, it's the petrol, it's the licensing fees, it's the dog food, the cat food, the vet's bills, the medical expenses where they are shared expenses. So for example, if you keep over-the-counter medications, those sort of things are included in that. So calculating expenses for children is different to calculating expenses just for a spouse if they're on their own. Direct expenses obviously then are directly for the children. So for example, if each child has their own cell phone or laptop or whatever, that will fall under just the children's expenses. If the children are at a specific school or university, those expenses are allocated to the children themselves. So some expenses will be joint type of expenses, and those are shared on that pro rata basis, as I explained. Or there are certain expenses like educational and medical aid and those sort of things that are expressly for a child and are put under a child's expenses directly. So when calculating the expenses for a child, it's a different calculation that comes into play. Now, let me see. Have I covered everything that you may need to know with regards to care and contact? There are a lot of nuances in care and contact that are very difficult to explain over an over a video, and are very sort of case by case. One of the things that quite regularly comes up is the question of, do I need the consent of the other parent to travel locally with the children? The answer to that is no, you don't. Do I need the consent of the other parent to relocate from one province to another? Yes. You don't necessarily need their consent, but you do need to take into consideration their views. So in other words, you have to tell them and before you move, and you have to let them express a view about that. And whether or not you can relocate will be based on the care and contact that is currently in place, and how you're moving will affect that. Then what comes up quite a lot these days is relocation to another country. And this is a whole different thing that can become extremely complicated, and I'd definitely have to do a whole series of videos on that. But that is something that you definitely 100% need the consent of the other parent, and it would have to be written consent, and you would then need a court order to give effect to that. So those are things that come up quite regularly. Then the other thing you just need to bear in mind is that parenting plan for care and contact of children is never fixed in stone. It is a flexible document, and it has to be, because children's needs change as they grow older, as they mature, as their schooling changes, as their sporting changes, their extracurricular activities change. All of those things have to remain flexible. So it's not something that is set in stone. Parents will often say, oh, but I need it to be that it must say that the parent will collect at 5 o'clock on the dot, and if they're late, then that's going to happen. It can't be like that, simply because life happens and things happen. And if, for example, unexpectedly you get called out on an urgent business meeting or something, and you can't collect the children at exactly 5 o'clock, you've got to be able to allow to be flexible, that you might be a little bit late, or on another day you might be a little bit early. So these are things that you need to bear in mind when it comes to care and contact of children, is that parenting plans are not fixed in stone. They are always flexible. And as parents, you need to be able to co-parent your children and be reasonable with one another at all times. I hope this helps. And please, again, if there are children involved in the mix, please, 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 whatever you do, try and get your spouse and you to mediation as soon as you possibly can, preferably before you've even instituted divorce proceedings, if that is at all possible.